My name is Richard Drabble. I'm joined by the other speakers at this webinar, Matt Fraser, here's their pictures, Alex Shattock and Tim Buley, Queen's Counsel. We've agreed that I'll just say a very few words about each of the speakers now, and then hand over to the presentations, which will run seamlessly, the web permitting, from then on. So Matt Fraser is going to talk about the EU, Appendix EU, some of the detailed points. He has lots of experience in appearing in immigration appeals and judicial review. Had a recent remote hearing in Cayley v. the Secretary of State, challenge about the bail regime under the Immigration Act 2016. That case was heard last week and is awaiting judgment, so it's all very topical. Alex Shattock is building up an impressive record of appearances in the FTT, the Upper Tribunal, and the High Court. I had a hard look at his chamber's website, which reveals a particularly expertise in the EEA regulations, which is relevant, and Scandinavian heavy metal music, which is less relevant, but probably more interesting. I say that without prejudice to what we shall learn about EEA law now. Tim Buley, Queen's Counsel, has spent substantial effort in attempting to convince me and others of the importance of the Withdrawal Act and other Brexit-related legislation as part of a fundamental constitutional settlement that we are going to have to live with for many years to come. So with that very short introduction, I hand you over to Matt and the detailed issues, or some detailed issues, arising out of the EU settlement scheme. Matt.
Good afternoon, everyone. Sorry about that. I was just trying to unmute my microphone. As Richard said, I'm going to be covering some of the current issues which are arising in relation to the EU settlement scheme at the moment. It looks like a slightly daunting list here that I'm going to be covering, but hopefully a lot of these we can skip through fairly quickly. I'm going to look at some statistics, what's going on in terms of refusals and delays, what's happening to the scheme in relation to COVID-19, and then start to look at some of the more specific issues arising under the scheme in terms of absences from the UK during the continuous qualifying period, Surinder Singh, criminality, and then look at some of the other issues to do with the scheme deadline, digital-only decisions, and so on. So starting firstly with some statistics. These are statistics which are periodically released every month by the government, and the latest that are publicly available at the moment are accurate up to the end of April 2020. And as of that, we've had over 3.5 million applications submitted in relation to the scheme, and number of applications concluded, over 3.2 million. You need to slightly take these statistics with a pinch of salt, because the number of applications submitted may well be in relation to the same person. So that person might have initially submitted an application for pre-settled status and then subsequently made an application for settled status. That would be the same person. And also the government are keen to point out that these actions are only the applications submitted online and via the app, not the paper applications. They haven't released any publicly available information about the paper applications, which has been the cause of some concern by a lot of those interested in the scheme, because the paper applications, as some of you will know, generally involve the more complicated applications, where, for example, you're relying on the Surinder Singh route, or you're applying as a carer. These are the sorts of applications which have to be made through the paper applications, and we don't yet know anything about the approval ratings of those applications. But of the ones that we do know about, there are 3.5 million have been submitted. Of the applications concluded, 58% were granted settled status and 41% were granted pre-settled status. So 99%, you might look at that and say, well, that's a 99% approval rating. That's not quite accurate, again, because there may well be many people who applied thinking, I am entitled to settled status, but instead have been granted pre-settled status. So that would be something that they're not happy with, and may well be seeking to review that decision or make a fresh application or appeal that decision. So it's not necessarily the case that you can say 99% of people are getting what they want or what they're entitled to. Of the applications remaining, 25,800 have received what's known as a withdrawn or a void outcome. A withdrawn outcome is where the applicant themselves have voluntarily withdrawn the application, and a void outcome typically relates to applications by, for example, British citizens who aren't entitled to the status because they already have something, which means they just simply don't need leave to remain in the country. There are also a number of invalid applications, and then 700 refused. And it's those refusals that are quite interesting. 700 out of a total of 3.2 million applications have been made, so a very, very low refusal rate. 99% of them refused on eligibility grounds. So that's, have you had the requisite period of residence? Have you proved sufficiently your identity and your residence in the UK for the requisite period? And only 1%, so that's essentially 7 applications out of the whole 3.2 million that have been refused on suitability grounds. So that's grounds relating to criminality and so on. In terms of refusals, the Home Office have said that many of those 700 are eligibility refusals that relate to cases that had been under consideration for several months, and in most cases subject to repeated unsuccessful attempts to obtain missing evidence or information from the applicant. And they also say that there are various reasons why there might be delays in an application. There might be a request for further information. The application may well be from a minor, which is not, that should say, linked rather than lined to an adult application. It might be a paper application. There might be a criminal record to contend with. There may well be an ongoing investigation or a prosecution going on, which will slow things down as well, because the application will be paused pending the outcome of that prosecution or that investigation. And then also there may well be cases where it's a non-EEA national who's applying for pre-settled status or settled status based on a relationship that they haven't previously relied on in an application to the Home Office. So that those are the sorts of scenarios in which a delay can be caused. What's happening with COVID-19? Well, the government back in early April said the scheme continues to be open and we're continuing to process applications, but it's going to take a little bit longer than normal because of the circumstances. Throughout the whole lockdown period, online and app applications and email support have continued. They've remained operational. However, telephone, helpline and postal applications have not been open for some time until the 22nd of May when they were reopened. Scanning service locations, so that's where instead of doing a postal application where you don't, for example, you might not want to send your identity documents. There are various locations around the country where you could scan in those documents and send them in, but those locations are currently closed and have been throughout. There has been an alarming reduction in both applications and decisions in April as against March, although it's not necessarily something to be too troubled by, because applications have been steadily declining anyway since January as more and more people apply and get onto the scheme. There has been talk of a lot of people have been raising a request for an extension to the deadline, which is, as we know, at the end of June 2021. But the Home Secretary said in late April that there was no reason to extend the deadline, given that there's still over a year left to run, and that's still the case. No extension due to COVID-19 at present. Now I'm going to go on to have a look at something which arises for a huge number of people. This is an issue which applies fairly frequently, and that's how do you deal with situations where there are absences during the continuous qualifying period. So the starting point is that EU citizens and family members will qualify for settled status, which is indefinite leave to remain, after completing a continuous qualifying period of 5 years of residence in the UK. So what is a continuous qualifying period of 5 years of residence? That's a period of residence. So again, really important to note, it's not anything to do with exercising treaty rights, working or being a job seeker or being a student. Residence alone is all you need. The residence has to have begun before 11 p.m. on the 31st of December 2020, which is the end of the transition period. And it cannot be broken by absence or absences, so multiple absences potentially, from the UK exceeding a total, so a cumulative total of 6 months in any 12-month period. So any 12-month period means a rolling period, which starts again every time you come back from a period of absence. The 12-month can potentially start from there again. Subject to exceptions. We're going to look at some of those exceptions, but it's worth bearing in mind that you also can't have had your residence period broken by a prison sentence or a deportation, exclusion or removal decision or order. So let's just drill down into some of these important numerical points. How many days is 6 months? That's one of the things which a lot of people have been asking about, because a month isn't defined in the rules, it's not defined in Appendix EU, it's not in any legislation. There's also no guidance on this. So people don't know whether it's 180 days or 182 days. There's been some Home Office guidance on in another context, long residence applications, which says that a month equals 30 calendar days. And I think the best advice at the moment would be stick on the safe side and assume that it's 182 days, 180 days rather than 182 days, and then you can't go wrong. What is a day? A day is a whole day. Parts of a day don't count. And what that means is that you could potentially get on the Eurostar and go to Paris, spend the night there, come back, and your day in Paris doesn't count as a day of absence because it has to be a whole day. Who's counting? Well, this is another thing which people are wondering about. You don't need to write out chapter and verse as to when exactly you've been away. You just need to be able to self-certify that the absences themselves don't exceed 6 months. But it's self-certification, but it's also subject to review. The Home Office obviously can check, for example, whether you've gone through an e-gate at an airport. So they will be able to verify what you're saying. So it's obviously critical to be completely honest. And that's related to another issue, which is that there can be a justified refusal of an application where it's clear that the applicant has been dishonest or misleading in their application. In terms of exceptions, this is a really interesting area, and it's particularly interesting due to COVID-19. There are exceptions to the 6-month rule. One can have a single period of absence which does not exceed 12 months and was for an important reason. So an important reason can be various things, including pregnancy, childbirth, etc. There are also some other exceptions, but this is really the most important one. And a lot of people have been saying, well, how does this relate to people who need to travel a lot for work? And that doesn't cut the mustard here, because it can only be a single period of absence rather than a collection of frequent trips. So if you have to travel for work, which takes you out of the country for 7 months a year, and it's a lot of individual trips, you're not going to be able to rely on this particular provision. And that's a lot of people have been saying that that's a real gap in the provisions. The other thing is COVID-19. What if you go away for a period of absence, which starts out being one of those important reasons? For example, pregnancy. Let's say you spend 9 months abroad for pregnancy-related reasons. that would be fine. But if COVID-19 in the meantime has intervened and has meant that your 9 months becomes 13 months, then there's going to be an issue in terms of your absence. But if there's nothing you could have done to get back, then a lot of people are saying, well, the regulations, that the rules need to be amended to deal with situations like that. Or there needs to be some general exclusion which is carved out for COVID-related absences. Any absence caused by or related to COVID-19 is not an absence for the purposes of the rules, or something to that effect. Let's look at some other absence issues. What happens if you exceed the limit? The continuous qualifying period that is required to obtain the settled status is broken, and the clock starts again from the date that you return to the UK, as long as that return happens before the 31st of December 2020. If it doesn't, then you're stuck with everyone else after Brexit and the transition period, relying on whatever immigration rules apply in that instance. You won't be able to rely on the settled status scheme any longer. As I said, coronavirus-related absences, no provision for that, but there has been talk, I gather, of a possible amendment coming in to deal with this. Absences after the continuous qualifying period are achieved. After you've got your 5-year continuous period, what if you then want to go away for longer? That's absolutely fine. A person can spend up to 5 years outside the UK without losing their entitlement to settled status. I'm just going to pick up a few other things. I'm conscious of the time. I'm not going to spend as much time on the other individual instances, but obviously if there are any questions that arise from them, then I'll be more than happy to answer them. This is a case which arose fairly recently, early March, which is all about what happens if you get granted settled status in the middle of a pending appeal against an EEA decision. For example, it might be an appeal concerning a refusal of the Home Office to issue a permanent residence card. The government tried to say that as soon as a status is granted, it means that any pending appeal that you have is deemed as abandoned. But that's not the case. The upper tribunal said that's wrong. And you might be wondering, well, why on earth does that matter if they've got settled status already? And the answer is it does have implications which go beyond the scope of this talk. For the next step, citizenship applications, there are advantages to having a permanent residence card vis-a-vis simply having settled status, but I'm not going to go into those now. Surinder Singh, again, this is an issue which could occupy an entire talk. This is a situation where a British citizen moves to another EU country, meets a partner or other family member there, comes back to the UK with them, and the British citizen in that context is treated as an EU migrant who can sponsor a family member. And the rules have very recently been amended to clarify exactly what and when the UK citizen and the relationship need to be in existence. So the UK citizen has to have been resident abroad, exercising their free movement rights before the end of December 2020. And they then need to return to the UK before 29th of March 2022. Now, that looks wrong, that date, but I checked it, and that is correct. That is what the immigration rules currently say. The return is before the 29th of March 2022, not 2021, as long as the relationship began before the 31st of January 2020, Brexit day. There's then a slightly different situation that arises if the relationship began during the transition period. Surinder Singh is one of those paper-only applications. The form is not publicly available. It can only be obtained by an applicant upon request, and it's apparently 61 pages long. So you certainly need to book out some time to enable you to fill out an application if you're going down that particular route. And I'll put a link at the bottom there, which usefully explains some of the recent changes to the immigration rules in relation to Appendix EU, and specifically Surinder Singh. Criminal offences, I'm going to rush over this because of time, but essentially the rules distinguish between pre-Brexit and post-Brexit offending. Pre-Brexit is subject to the much more immigrant-friendly laws on deportation on grounds of public policy. whereas post-Brexit offending will be subject to current UK deportation rules for non-EU citizens, which are much more draconian and difficult to appeal against. So that's the situation in relation to criminality. Non-EEA family members, can they get status? A lot of people commonly misunderstand that the scheme isn't there just for EU citizens themselves, but also family members of EEA nationals. They're entitled to settled status and pre-settled status on the same basis as EEA nationals. All the same deadlines and application process applies. What happens if an application is refused? Well, if you're in time, you can just resubmit another application. You can keep doing that as long as you like. That's absolutely fine. It's completely free, or you can alternatively seek administrative review, where there's a refundable £80 fee, where your application will be reviewed by a different person, but still the Home Office. You can submit new evidence, there's a time limit, and then there's obviously then a full right of appeal to the FTT. Now, there may well be lots of people on the call who have experience of appeals. I couldn't find any decisions myself that are online yet. It'd be very interesting to see how the tribunal start approaching some of these appeals. So if anyone's got any that they have seen recently, I'd be very interested to know about them. What happens if you miss the deadline for applying? This is I think one of the last, I think it's the penultimate thing that I'm going to deal with. This is a really interesting issue because at the moment, the deadline, unless it's extended due to coronavirus or something like that, the deadline is the 30th of June 2021. You have to have made your application in the scheme by that date. That's when the scheme runs till, and there isn't anything to suggest that there's going to be any extension at the moment. But the withdrawal agreement under Article 18(1)(d) says that where the deadline for submitting the application is not respected by the persons concerned, i.e. the applicants for status, the competent authorities shall assess all the circumstances and reasons for not respecting the deadline and shall allow those persons to submit an application within a reasonable further period of time if, and I think this is the critical part, if there are reasonable grounds for the failure to respect the deadline. Now, as far as I can see, looking through Appendix EU or the guidance or anything else on the government's website, there is absolutely nothing about or to give effect to or to implement this provision of the withdrawal agreement. There was a very general statement from the government in early 2020 that people might be allowed to apply for settled status or pre-settled status after the deadline if good reasons were shown. But we know nothing about what those reasons might be, or very little to actually give any flesh to this apparent commitment from the government that they're going to allow people potentially in some circumstances to apply after the deadline. I think the government just keeps saying, well, just apply under the scheme and then we'll cross that bridge when we come to it. But I think it's really important to understand how the government is intending to give effect to this very important provision of the withdrawal agreement. And we just simply haven't had any detail on that at the moment. Lastly, and just a small point, I think it's quite interesting that there was an application for judicial review brought in Northern Ireland against the fact that decisions on settled status are online only, so you don't get a paper certificate saying you have settled status. And there was a challenge brought against this saying that such a scheme is irrational, fails to take into account mental health issues that particular applicant had. It was a breach of their right to private and family life, and that it was dismissed as unarguable by a judge of the High Court of Justice in Northern Ireland, given very short shrift. And it's interesting to note that the withdrawal agreement itself entitles the UK to have an online-only system, so that failed completely. So I hope that's a very quick run through some of the issues which are arising at the moment in relation to the settled status scheme. I'd be very interested to hear from anyone who's had more direct experiences of ongoing appeals or applications that have been causing difficulties. So do please get in touch after the seminar. Thank you very much indeed. I'll now pass it over to Alex. Thank you.
Hi there, my name's Alex, and I'll be talking about Fratila and the Secretary of State for Work and Pensions, a case about pre-settled status and benefits, in which two members of this chambers, Charles Banner and Yasser Vanderman, intervened for the Air Centre. Firstly, how does EEA national entitlement to social security benefits work? Well, let's focus on one example, universal credit. The legal framework for universal credit is found in the Welfare Reform Act 2012 and the Universal Credit Regulations 2013, SI 376. And you'll see that Section 3 of the Welfare Reform Act 2012 provides that a single claimant is entitled to universal credit if he meets the basic conditions and the financial conditions for a single claimant. And Section 4 of the Welfare 2012 Act sets out 4 basic conditions, 5, and you'll see that the key one for our purposes here is that the person has to be in Great Britain. Now, I know what you're thinking, that's all very straightforward, Alex. Why on earth do we need to get barristers involved in Great Britain? That couldn't be clearer. However, this is Regulation 9 of the Universal Credit Regulations 2013, and it makes this simple phrase, in Great Britain, horrendously complicated. It's a difficult regulation to get your head around, but essentially it provides that despite living in the UK, you're not treated as being in the UK for the purposes of the regulations unless you're a worker or a job seeker under EU law, or you have a right of permanent residence. For example, under Regulation 15 of the EEA Regulations 2016. In practice, this means that EU national universal credit claimants often need to marshal a significant body of evidence to show that they've acquired a permanent right of residence if they're not currently in work. Regulation 15 of the EEA regulation states that EEA nationals only get a permanent right of residence if they've been living in the UK in accordance with the EEA regulations for a continuous period of 5 years. So after your initial 3 months, claimants usually need to show that they've been working or seeking work for 5 consecutive years, and or that they've enjoyed a derivative right of residence during that consecutive period. There's a lot of law on this, and it often comes up in deportation appeals, which I know Matt has a lot of experience doing. And it comes up in this context because it's much harder to deport EEA nationals with a permanent right of residence. So that's how EEA nationals can obtain universal credit. Where does pre-settled status come in? After the 7th of May 2019, Regulation 9 was amended by the snappily titled Social Security Income-Related Benefits Updating and Amendment EU Exit Regulations 2019, referred to as SURBOAWA by absolutely no one. SURBOAWA inserts a new qualification to Regulation 9 of the Universal Credit Regulations. And that qualification is as follows. For the purposes of paragraph 2, a right to reside does not include a right which exists by virtue of or in accordance with a person having been granted limited leave to enter or remain in the United Kingdom under the Immigration Act 1971 by virtue of Appendix EU. So basically, the rule change meant that persons with pre-settled status under Appendix EU cannot be considered as being in Great Britain and therefore are not entitled to universal credit. The 2019 Social Security Regulations amended these other rules too. In some, but not all, of these other welfare benefit schemes, the test is also put in terms of whether the claimant is in Great Britain, but overall, the 2019 Social Security Regulations amended all of these schemes to prevent reliance on pre-settled status to meet the residence tests, which are a condition of entitlement. We've just covered Appendix EU in Matt's presentation, so I'll turn straight to Fratila. Fratila challenged all of the amendments I've just referred to on the basis that they led to unlawful discrimination on grounds of nationality, contrary to EU law. The Fratila challenge was a discrimination challenge, effectively, to pre-settled status. The claimant said it was contrary to EU law to treat UK citizens better than EU citizens in the context of benefits. Article 18 TFEU provides that within the scope of application of the treaties, and without prejudice to any special provisions contained therein, any discrimination on grounds of nationality shall be prohibited. And there's a body of case law on that under the old Article 12 TEC. In response to that, the Secretary of State said, hang on, the case law you rely on predates the Citizens' Rights Directive, which codifies EU discrimination law. And Article 24.2 of that directive gives us, the government, a derogation in the case of social assistance. So you can't rely on Article 18. However, Mr. Justice Swift disagreed. He said that just because direct reliance on Article 18 didn't come up in the cases that post-date the Citizens' Rights Directive, that didn't mean Article 18 could not be relied on in appropriate circumstances. He said that there was nothing in the reasoning of the CJEU in either case that barred reliance on Article 18. And he held that in this case, pre-settled status is a right of residence that exists apart from, it is different to, anything available under the Citizens' Rights Directive. Its legal basis is found in the rules made under the Immigration Act 1971, and furthermore, pre-settled status is wider in scope than the EEA regulations which transpose the directive. Accordingly, the judge held that one of the claimants, Mr. Tanasi, was able to assert a claim of indirect discrimination under Article 18 TFEU. The next question was whether or not there was discrimination. And if there was, what kind of discrimination it was, direct or indirect. This is an important distinction because indirect discrimination, as we know, can be justified, whereas direct discrimination cannot be. The judge held this was a case of indirect discrimination, not direct discrimination, effectively because there was no exact coincidence between the requirements and the prohibited characteristic of nationality. In other words, it is not the case that all British nationals are entitled to universal credit following the amendments and all EEA nationals are not. It is only that a much higher proportion of British nationals will be eligible compared to EEA nationals. However, because of that greater effect on EEA nationals, the judge held that there was indirect discrimination here, which in my view is the correct analysis. However, and this may be where the appeal in this case in the Court of Appeal focuses on, the judge found that the indirect discrimination was justified. And he said a number of things about this. Forgive me, my mouse seems to have died at an inopportune moment. He said that a justification must be capable of validating each specific part of a provision under challenge, which is interesting because that shows that you can't have a broad brush approach to discrimination under EU law. You have to consider the justification for each individual part of the scheme. The judge also accepted the purpose of the requirement was protecting the social security system in the United Kingdom from persons who come to the United Kingdom to live off benefits rather than to work. So there was a fairly clear political justification for this scheme in this case, and the judge didn't engage with that or didn't feel it was appropriate to engage with that in terms of legal analysis. And related to that, he said that there was a principle that EU nationals should contribute to the economy before receiving taxpayer support. But the final thing, and this is what I think is the killer point in this case, Appendix EU rights supplement existing rights of residence. So the scheme we talked about previously under Regulation 9. This is in addition to that. So if Regulation 9 before was justified under a discrimination challenge, the court held that, well, Appendix EU doesn't take away anything from EA nationals. The status quo is maintained. Oh, thank you. So what are the implications of that? Well, I think the key implication, which is in the context of the coronavirus crisis, is that there'll be lots of people who aren't entitled to universal credit. And this is a worrying development, as many EEA nationals in the UK will lose their jobs. And sectors such as the hospitality sector have a very large number of EEA nationals in them. So, and also this case is being appealed, but the request to expedite the appeal has been rejected. So we're not sure when this is going to go before the Court of Appeal. Another point is whether there is a divergence between the Equality Act 2010 and Article 18 is on the horizon. This is a case which didn't consider the Equality Act, and so anything that comes out of this on appeal or in the High Court relating specifically to Article 18 TFEU may not have a direct application to Equality Act discrimination claims. So I think there's an interesting question there as to whether these two linked areas are going to diverge even further, and the extent to which something that's relevant to one is relevant to the other. There's also this justification point, which I've already referred to, and the fact that courts don't want to get into political debates, and especially in these Brexit challenges that are coming up. I think we'll see increasingly, if there's a highly political justification for a particular measure, courts, in my view, are going to be unlikely to want to engage with that sort of political justification in a particularly detailed way, which may be an issue when we get to the question of proportionality. And the way proportionality was dealt with in this case was quite interesting, because it was referred to at paragraph 30, but there wasn't much of an engagement with it, and it's not really clear the extent to which the justification is basically the same thing as saying proportionality. And if there is going to be a full proportionality assessment, you would expect to see the consideration of all the different proportionality points, including the no less onerous alternative, which isn't really grappled with in this case. And again, if proportionality is relevant, to what extent does a proportionality assessment apply in respect of each individual part of a scheme, as with the justification, or is it more of a broader overall, is this a proportionate scheme or not under EU law? And again, the intensity point kind of links into that point about these being quite highly political challenges, and judges not wanting to engage in the ins or outs of the principle of universality, say, in the social welfare system we have. Try to change the slide. Yeah. So just in terms of where this is going next, as I said, it is going to the Court of Appeal, which will be an interesting case. We don't know when that's going to be, because it's not going to be expedited. CPAG have put out something on their website saying the claimants will argue that although the Court of Justice has not considered whether discrimination of this sort is direct or indirect, it has been clear that such discrimination is prohibited, and the claimants say that's the correct answer to this claim. So we're not quite sure yet what the appeal is going to focus on. I would expect it to focus on the justification question, because as I said, there's some quite interesting issues there that arise on the question of justification in these kinds of challenges. Right, I will now pass on to Mr. Tim Buley QC.
Thank you, Alex. Have I got control of the screen? Yes, I do. Great. Hello, everyone. So slight change of pace with my talk. I'm going to be talking about a slightly more abstract issue, which is not about the detail of a particular case or a particular set of circumstances, but the kind of general conceptual and legal framework which we now have for deciding whether EU rights, and in particular in the immigration field, EU rights are being preserved, and what kind of arguments you may be able to make about them, about interpreting those rights if they exist, in particular around the EU Charter of Fundamental Rights. So the question is, you know, are the rights, are pre-existing EU rights preserved, and if so, what are the limits of the arguments you can make about their interpretation? Should say the talk this talk is then concerned with EU immigration law after the end of the transition, or what's called in the legislation the implementation period. Obviously, we left the EU on the 31st of January of this year, but we're only going to cease, the EU law will only cease to apply on the 31st of December. So for the time being, whether or not your clients can benefit from the rights that Matt's been talking about in the settlement scheme, they for the time being, insofar as they cannot satisfy the test, they can still demonstrate they have EU rights of free movement. But that's all going to change potentially on, well, that's all going to change on the 31st of December, or at any rate within 6 months of that, as we'll see. There are two, just by way of overview, there are two critical pieces of primary legislation, and the way this works is really about the interaction between the two of them. And I've underlined and put in bold the difference between them at the moment, because the first of them is the European Withdrawal Act 2018. That was amended at the start of the year to take account of the withdrawal agreement, but it's still the primary piece of legislation that governs not immigration law, but in general, which governs the law relating to preservation of EU law in general. The other one is still a bill at the moment, the Immigration and Social Security Coordination EU Withdrawal Bill 2019-20. That's going through Parliament at the moment. And so, as we'll see, it's about the interaction between those two pieces of legislation. The other thing, though, to be aware of, the other main piece of legislation, I mean, there's lots and lots and lots of other legislation. There's lots of detailed secondary legislation. I don't plan to be on top of it, and it would take a year to give a talk about it all. But the other main one to be aware of is the regulations which are in the final bullet point, the 2019 regulations. They're made under the 2018 Act, and they have a significance which I'll come to in due course, but it's less, it ought to be, and I think it probably is less significant than the bill going through Parliament at the moment. Okay, so what about the Act? So this is a pretty complicated topic, and I'm going to take it at a bit of a canter. Forgive me, please do ask questions about there are lots of interesting and difficult questions which arise about this, which I'm only going to touch on briefly. So the Act makes detailed provision about the retention status and amendment of EU law following Brexit. It is, as Richard Drabble touched on in the introduction, certainly I think it is a pretty important constitutional statute. So if you're involved in bringing sort of big public law challenges, it's something you're going to need to get your head around at some point. I've given talks specifically about the Act, and this is a bit of a canter through. Lots of uncertainty about it works, about how it's going to be interpreted and how it works. Notwithstanding that it's so important, it's frankly not particularly clear, I think, although the basic scheme is simple enough. What does it do? Well, first of all, Section 1, big bold statement, Section 1 of the 2018 Act. The European Communities Act 1972 is repealed on exit day, and that remains, I think, a reference to exit day. Exit day has passed. The European Communities Act 1972 is the provision which for the last, whatever it is, 38, 40 odd years, 50 years, has given us EU law. So its repeal is pretty significant. But as we'll see, that's subject to some pretty major caveats. The first is that even though we've exited, exit day was the 31st of January, that's now amended to allow for transition, and Section 1 big A of the Act preserves the European Communities Act for most purposes for the next 11 months. So none of this matters yet, but will matter in 11 months. Secondly, as we'll see, there are some major exceptions even after the end of the transitional period. So, if I can get my screen to change. Yeah. Sections 2 to 7 provide for major exceptions to the repeal of EU law, and indeed so as to preserve most EU law in force on exit day. And what it provides for, in particular sections 2 to 4 provide for, are 3 categories of retained EU law, and they are pretty much exhaustive of EU law, give or take. So all EU law which has effect in the UK and which could be relied upon in a UK court prior to exit day, or prior indeed to the end of the implementation period, should in principle be covered by one of these. There are some exceptions to these exceptions. I'm not going to get into that. And let's just look at them in slightly more detail. So section 2, first of all, saving for EU-derived domestic legislation. So this preserves in force, I mean, it's not all domestic legislation which is implementing EU law. That covers both, oddly, it covers both primary legislation, which would be preserved even without this, but more important, critically and importantly, it covers secondary legislation. So in principle, for example, the Immigration EEA Regs 2016, which provide for the implementation of EU law, would be covered by this. They're secondary legislation on our statute books, which would be therefore preserved by this section, and that's true for all forms of EU law. And so you can see that what you basically do here, and with all of this, all 3 of the sections I'm just briefly covering, is you preserve the status quo, things remain unchanged even after exit. But that is subject to more detailed provision made elsewhere, which is what we'll come to. So that's section 2. Section 3 is about direct EU legislation. That's things like treaty rights and in particular regulations which are designed to have direct effect in UK law in terms of the way EU law works. I'm going to skip over that, take that point relatively quickly. Section 4, though, is more interesting and worthy of note. Section 4 is a slightly sweeping up provision, and it provides for the retention of any other rights, powers, liabilities, obligations, etc., recognised before exit day by virtue of the ECA 1972. Now, the bit here which is going to be most controversial, perhaps the most interesting to immigration lawyers, indeed to many other kinds of lawyer, are that it's actually section 4 and not section 3 which deals with directly effective EU directives. And there's a curious but potentially quite important exception in relation to directives, which is as follows. It's in section 4.2b. So this is things that are not preserved, namely rights which ... arise under an EU directive and are not of a kind recognised by the European Court or any court or tribunal in the UK in a case decided before exit day. Note those words, not of a kind recognised by the European Court, etc., or a domestic court in a case decided before exit day. Now, that's potentially this is one of the areas where the Act is really quite unclear, and this could be quite important, because the way I would read that, and I think the way others have read it, if you just confine yourself to the language of the statute, is that that's concerned with, what that is dealing with is not whether the particular directive has already been recognised as being directly effective, but whether, applying the general principles which the European Court applies to whether a directive can be directly effective, it is of a kind which is capable of being, or which would be recognised as directly effective. If that's right, then the relevance of the words recognised by the European Court before exit day, etc., is saying, well, effectively, we're freezing the principles which apply to whether a directive is directly effective, and they can't, and if the European Court later expands those principles, that doesn't matter. But the explanatory notes to the Act suggest something quite different, and they say effectively that the particular right has to be recognised before exit day. So, for example, if you're relying on the trafficking directive, as it may be, and you're saying that confers a directly effective right, then you have to get a court to rule on that either already or at any rate by the 31st of December 2020. Now, I don't think that's the right interpretation, but it's one issue to be aware of, because if I'm wrong about that, and it's by no means clear, then you may need, if you're interested in bringing strategic litigation, you may need to be thinking about bringing that case and getting a court to rule on it before the 31st of December 2020. So that's quite an important issue for some NGOs, for example, which are considering strategic litigation. So much for section 4. Then there are 2 exceptions to the retention of EU law. The first I'll take very quickly. It's the principle of supremacy of EU law. This is very important to constitutional law academics, but its practical consequences are probably less. So I just want to move straight on to the other exception, which is going to be potentially much more interesting. And that relates to the Charter of Fundamental Rights. So the big question here, can you, after exit day, rely upon the Charter of Fundamental Rights? And there's something of a kind of paradox or a fudge going on here, because section 5(4) of the Act says that the Charter of Fundamental Rights is not part of UK law after exit. That seems pretty clear, you might think. So no reliance on the Charter in any circumstances after exit day. Fine. But section 5(5) says that this does not affect the operation of EU law, fundamental rights or principles which exist irrespective of the Charter. And as is reflected in the Charter itself, I haven't quoted it, but you can see it in the explanatory notes here. In fact, the Charter itself says it doesn't create new rights. All that the Charter was ever intended to do, and you may say this is a legal fiction, but it's certainly what the Charter, it's a legal fiction which the courts, including the CJEU, have accepted, it is that the Charter never created any new rights. All of the rights which it sets out are, so goes the theory, latent in EU law already. And that means that, as it says, it codifies those rights, but they're already part of EU law, because fundamental human rights principles were part of EU law since the very start of the EU. And therefore, as the explanatory notes point out, since the Charter did not create any new rights, subsection 5 makes clear that whilst it's not part of our law, it doesn't remove those rights. In other words, it's still those rights, the rights are still part of domestic law, and you can presumably look to the Charter to see what the rights are. And if that sounds all a bit theoretical, effectively exactly the same fudge was used in a series of cases which culminated in the NS Afghanistan case, the final bullet point there, to justify the Charter being part of UK law, even while we were still part of the EU. That's because Tony Blair in around about 2007 signed a declaration which was part of the treaty bringing the Charter into effect, which said doesn't create any new rights in UK law. And the court said, yeah, that's fine, we accept all that. But of course, since these rights already pre-exist, that doesn't matter. The Charter is part of our law. And it's difficult. I don't really see why, if that was true, and it was true, that's what the courts decided and our courts have recognised, why it should be any different with this clause. And the explanatory notes indeed support that. All of that means, then, I can see a note saying that the audio is breaking up. I hope that's all right for everybody. I'm going to keep going until someone tells me it's different or that it's a more general problem. What that means is you can rely on the Charter, notwithstanding section 5(4). House of Lords Constitution Committee was critical of that, not because the Charter shouldn't be preserved, they thought it should, but because I've seen someone else saying, fine for me, the audio, so I'm going to hope that it's just, I'm sorry for the person who's having a problem, but I'm going to crack on. But it was critical of the lack of clarity, and you can see why. However, importantly, and we'll come back to this when I get on to the detail of immigration law, the Charter, doesn't mean you can just rely on the Charter for any purposes, and indeed, you can't rely on the Charter for any purposes now. If anyone's ever done a case about the Charter, you can't just rely on the Charter in all circumstances, because the Charter itself only applies when the UK or when the member state is acting within, according to the language, the material scope of EU law. See Article 51 of the Charter, and for example, see the Zagorski case, which was about drugs on death row being exported from the UK. So you can't just always rely on the Charter. You can only do so when the UK is implementing EU law. That can be a tricky question, I should say, even at the moment, to work out whether the UK is implementing EU law. So in Zagorski, my client was trying to argue for the Charter, to rely on the Charter to prevent drugs being exported from the UK for his execution on death row in the United States. The court held that the EU law did provide for rules governing exports from the Union, but the UK had not made any such rules pursuant to its EU powers. The courts held that it was enough that the UK could have made those EU provisions, or the UK or the Union could have made such provision to say that it was acting within the material scope of EU law. So it's quite broad, but can be quite tricky. Straightforward when you're dealing with a straight free movement case at the moment. But going forwards, and we'll come back to this, that's going to be really tricky. Straightforward enough again when you've got an existing bit of EU law which is fully preserved, but as soon as you move away from that, or as soon as you think about the exercise by the UK of a discretion, is it ever going to be acting within the scope of EU law? Well, the case law will develop on that. I don't think I know the answer fully at the moment, or I'm not at all sure. I'm not sure I know the answer really at all. All we can do so far is identify the issue, but that's going to be an important limitation. So, in the general sense, can you rely on the Charter after exit? Well, yes, sometimes, but exactly when, really tricky issue. Okay, relatively quickly then, because I want to move on to the bill. Section 6 is about the interpretation of EU law after exit. There's some quite complicated stuff I won't go through here, but it's all in the notes about when a UK court is bound or should have regard to CJEU decisions. And note also the very curious and problematic power in section 6.5a now, where the ministers have power to extend that by secondary legislation. That's really constitutionally significant, but it's not the subject of this talk, so I'll note it and move on. Okay, last point on the 2018 Act, secondary legislation. So remember, where we've got to so far is that all EU law is preserved, subject to provisions saying otherwise. You can obviously have, and we're going to see this in a minute, primary legislation saying otherwise, but the ministers have a limited, but actually quite broad power to make secondary legislation on the 2018 Act. To do what? Well, to deal with, see the first bullet point, to deal with deficiencies arising from withdrawal, namely to prevent, remedy or mitigate any failure of retained EU law to operate effectively, or any other deficiency in retained EU law arising from withdrawal. What does that mean? Well, it's quite broad, but the general point is it's to deal with the sorts of problems which will arise because we've left the EU and these provisions just don't make sense anymore. And in fact, an example which some of you will be familiar with, where the power has been exercised already, which I think illustrates the more general point as well, is in relation to the Dublin III regulations. So one of the things that the 2019 regulations, the ones I put on the very first slide, does is repeal the Dublin III regulation post-exit. That was inevitable because once we've left the EU, other member states, or member states, I suppose I should say from that date onwards, because we're no longer one, will have no obligation to accept people back. So if we try to rely on the Dublin III regulation to return asylum seekers to countries that they've passed through on their way to the UK, France, Italy, whoever it is will simply say, no, sorry, we've no longer any obligation to do that. You're not party to the Dublin III regulation. And therefore, there's absolutely no point in having provision for that in our domestic law. Whereas, if you've got a provision relating to asylum law, for example, we'll come on to an example of that, then that doesn't have that, create that coordination problem. It doesn't have to, you don't have to be a member of the EU to apply the Refugee Convention, and so you can't make that change. And so unless you've got a technical problem of that kind, you shouldn't be making secondary legislation under the 2018 Act. Okay, hopefully the screen will shift. Yeah, so that brings me on to the immigration bill. This is pretty simple in a way, depressingly simple you might think, to those of you with an affection for the EU, but it does two things. It makes provision about, first of all, the ending of free movement rights, and secondly, provision relating to social security coordination. And note that it's doing two very different things. In relation to free movement, it ends the rights, it simply brings them to an end, those rights won't exist anymore. Whereas in relation to social security coordination measures, I'll come on, for those of you who aren't familiar with it, I'll say a bit more about what that is in a moment. All it does is it makes some general provision enabling the Secretary of State to make regulations in the future. It doesn't, for the time being, change the law, but it contemplates the Secretary of State doing so. What about free movement then? Well, first of all, and immigration more generally, Section 1 gives effect to Schedule 1, which it says makes provision to end rights relate to free movements of persons under retained EU law, and also end other EU-derived rights relating to immigration. Although it says other rights relating to immigration, in fact, most of the focus, as far as I can see, is very much on free movement. So, Schedule 1 then tells you what they are. Most importantly, on a day-to-day level, the Immigration EEA Regs 2016, that's the ones under which implement the Citizenship Directive, they are going to be repealed, they're no longer being enforced. And Part 3 makes clear that rights which might otherwise exist under an EU directive will also not be retained. I think that's necessary because otherwise someone might be able to try and rely on the Citizenship Directive, for example, directly. That's not going to be possible. By the way, I should have said that the Act doesn't say anything about when these measures take effect. But Matt has been talking about, in the context of the settlement scheme, the fact that in fact people will retain their EU rights for a period after exit day, and I think it's 6 months, so it will be till June 2021. If you look at the explanatory notes, the Act, as I say, doesn't say anything about that date, doesn't guarantee that date, but the explanatory notes makes clear that that will be done, and it will be done via secondary legislation, presumably via transitional provisions and commencement provisions and things of that nature. So free movement rights will end, but not necessarily or completely on the for those who already are here, not necessarily in relation to not necessarily on the 31st of December. I've just seen a question pop up about the qualification directive, and I'm glad to say I'm going to come to that in a minute. So what's the effect of all this? Basic effect of the bill, if passed, will be simply to remove all these free movement rights. EU migrants will revert to effectively domestic law and non-EU law immigration rights, subject to, of course, and in accordance with Appendix EU and the immigration rules more generally. So if you think about the question posed at the outset of this talk, what about the preservation of EU law in relation to in relation to immigration? Well, in relation specifically to free movement, the short answer, I'm afraid, and I'm personally very sad to say, is it comes to an end. That, I think, means that there's really no scope to argue that the law is retained. And equally, therefore, in relation to the Charter, although in principle you'll be able to make arguments about the Charter for the reasons I've explained a moment ago, I think it's going to be quite difficult to argue to rely on the Charter in relation to free movement issues, or whatever replaces free movement for EU citizens, immigration rules, because I don't see how you can say that the UK is acting within the scope of EU law once the relevant provisions for free movement have been repealed. But, and I've dealt with this in a single bullet point, and I wonder if it deserved now more, I wonder about Appendix EU. I would have thought that a respectable argument, at least, could be made in relation to Appendix EU, which was brought into force predates the coming into force of the bill, and of course it predates our exit from the EU. I would have thought that a respectable argument could be made that the UK is implementing EU law and/or is implementing its obligations in the withdrawal agreement via Appendix EU, and therefore that the Charter can be relied upon. But that is a tricky question, and is going to turn on this very difficult concept of scope, what is within the scope of EU law, in a kind of the uncharted territory of, well, how do you say when we're acting within the scope of EU law when we've actually left the EU? Okay, and then other immigration preserved rights, and this is, someone asked about the qualification directive. So the bill doesn't touch some other bits of EU immigration law which may be of particular importance for those working at the sort of sharp end of asylum and trafficking and things like that. The bill doesn't touch the qualification directive, doesn't touch the procedures directive, both of which make quite an important provision relating to asylum. It doesn't touch the trafficking directive. And so those will all become, under Section 4, I suppose, or combination of Sections 2, 3 and 4, part of retained EU law post IP completion day, post at the end of this year. And in relation to these, therefore, EU rights are, for the time being, fully preserved. Now, that's obviously subject to further legislation, but it's there for now. And that also means that EU case law will continue to be relevant and potentially binding, depending on dates, depending on the detail of Section 6 of the 2018 Act, which I skimmed over, but I'm happy to talk about. EU law, the Charter, I think, remains potentially applicable in this sphere, because I would have thought it's much easier, not completely straightforward, but much easier to say you're acting within the scope of the Charter when you're dealing with these provisions, which remain part of our law. And then also there's this tricky issue, which I touched on. What about things that haven't yet been recognised as directly effective rights under those provisions, but where the EU recognise, where there is a respectable argument they could be recognised? Well, I think there's a good argument you can continue to argue for new directly effective rights, provided you're applying the general principles of the CJU. So it's the kind of thing they would have recognised previously. Finally, then, what? Sorry, I think I've got a repetition of the slide. Sorry about that. Right. Okay. Finally, then, so this should probably say 5, not 6. Immigration and Social Security. Social Security now. So this is a specialist subject for some, completely incomprehensible to many. Speaking for myself, it's both a specialist subject and incomprehensible. I think Richard Drebble may share those feelings. Unlike the free, so there are some very complicated, nightmarish EU law provisions, and most notably EU Regulation 883 of 2004, which make provision for coordination of the social security schemes or different member states. So this is the sort of thing which enables you, for example, to go and work in Germany for 3 years, make your contributions in Germany, you move then to France, or it may be the UK, and your contributions, i.e. your national security, your national insurance contributions, or whatever the equivalent is in Germany or France, will be counted so that you're treated as though you've worked here. That's one of the things it does. It makes, and then I've given 2 examples from cases about other things. There are circumstances where you may be able to, if you're a non-UK citizen, you may be able to rely on social security benefits under Reg 883/2004 in certain circumstances. And equally, if you're a UK national, there are certain circumstances, and there's a recent Tolley case on this, a case I'm doing in the Court of Appeal next week, where people can claim UK benefits whilst living in a member state. And all that clause 5 of the bill does there is that it enables the relevant authority, which I assume will be the Secretary of State within England at least, to make provision going forward about that, and to amend those regulations in the future. So he's not got the limited powers under the 2018 Act of making amendments to make sure that EU law is effective. He can make substantive changes now, but the bill doesn't make those changes, and I wouldn't necessarily hold your breath on how quickly those changes are going to be made, because although it's politically quite interesting, it's also incredibly complex, and it's going to mean it's going to rub up the noses of other member states to some extent if we make changes which deny their nationals benefits. And then they're going to make reciprocal provision. It's all going to be quite complicated. So in this area, for the time being, those social security coordination measures are retained. And what I've said previously on the last slide about the qualification directive, for example, would be equally true here. It seems to me you can rely on the Charter, and the EU rights are preserved for the time being. Okay, thank you for listening. I hope that all made sense. That's a whistle-stop tour, really, of some really quite complicated topics. But I hope that was of use, and I look forward to seeing if anyone has any questions. Thanks very much. Hopefully someone's taken the screen back. Yeah, great.
Right, well, I hope people can hear me. I'd like to first of all thank all 3 speakers for quite excellent presentations. This stage in any normal, non-virtual seminar or lecture, you would invite the audience to show their appreciation in the traditional way. It doesn't really work like that because you're all muted, so you'll have to keep quiet. But I personally do want to thank the speakers. I thought they were excellent and very informative talks. So can we now move on to the question and answer session? We obviously have been watching, or at least some of us have been watching the issues that have come through on the chat show. Most of them relate to Matt's talk. So I think the simple thing to do is just to hand over to Matt. It may be impossible for him to answer all of them in these contexts, but if he can have a stab at as many as he feels comfortable with, I'll just hand over to Matt. So there you go.
Thanks very much, Richard. Yeah, I'm not going to answer them all, but there's certainly there's a couple where consistent themes are coming up. There's some questions about how does the absence rule work in relation to pre-settled status. There's some questions about divorce. There's a Surinder Singh question. So I'll try and pick up a few of those. And then anything I haven't answered orally, we'll make sure is in a written response after the webinar. The first question that came in, and actually came in separately to the chat box, was that in relation to the absences rule, if the EEA national leaves the UK as part of an exception to the 6-month maximum for absences, does that mean that the non-EEA national who has pre-settled status based on their relationship with the EEA national, do they have to leave with the EEA national on those absences, or can they continue to live and work in the UK? And the answer is that there's nothing in the rules that requires a non-EEA national who has pre-settled status as a durable partner of an EEA national to accompany them if they go on a period of absence away from the UK, whether within the 6-month maximum or pursuant to one of the exceptions, the qualifying exceptions. That said, in order to be a durable partner, you need to have lived together in a relationship akin to marriage or civil partnership for at least 2 years, and you need to provide evidence that you've been living together. So if you've got a prolonged period of absence away from the UK without your non-EEA national partner, then it may raise a question about whether you can qualify as a durable partner because you haven't got any proof that you've been living together. So that's just a little wrinkle to that answer. Another question that came in, again separately from the chat box, was does an EEA national have to be a qualified person, i.e. a qualified person under Regulation 6 of the EEA regulations, in order for their family member to continue to enjoy pre-settled status? The answer is no, they don't need to be a qualified person. This was a deliberate decision that was taken by the UK government. They didn't need to do that. The withdrawal agreement says that it would have been a permissible restriction to require people to be qualified persons in order to avail themselves of status. But the settlement scheme which the UK has opted for is a far simpler one and far less restrictive, in that it only requires proof of residence rather than exercising treaty rights. So both the EEA national and any qualifying family member need only be residing in the UK prior to the end of 31st of December 2020 to get pre-settled status, and then to be residing in the UK for a continuous 5-year period to get the settled status. No further requirement beyond that. There's then been 2 questions that have come in which arise from a situation of divorce. So where you are yourself a non-EEA national and you've got pre-settled status on the basis of your relationship with an EEA national, but the relationship breaks down and there's then a divorce. One of the questions raises the issue of domestic abuse. What happens if the relationship broke down because of domestic abuse? And another one just says, well, there hasn't been domestic abuse, but there's just been a straightforward divorce. What's the situation then? And the answer is that it is possible under the scheme, and there is express provision for this, to apply for pre-settled or settled status as the family member of someone, even if you're no longer their family member. And the obvious situations in which this arises are death on the one hand and divorce on the other. And so within divorce, there are express circumstances in which you can carry on accruing your residence, even once you've lost your sponsor. The first is where the marriage lasted for at least 3 years before the divorce proceedings started, and the couple had been living together in the UK for at least 1 year. So that's enough to enable you to carry on being entitled to the scheme. The second is where the applicant has the custody of the ex-partner's child. Thirdly, where the applicant has court-ordered access to the ex's child. And then finally, and this is the domestic violence provision, where there have been particularly difficult circumstances. That's the phrase, particularly difficult circumstances, which my interpretation and others' interpretation is that this is applying to things like domestic abuse that has resulted in the relationship breakdown. So that's an answer on those points. Another question that came up was, can an EU family member submit an application for a retained right of residence under the EEA regs if he has already been granted leave pursuant to the private life route in the immigration rules relying on Article 8? The answer is yes, they can. EU law is an independent source of entitlement to leave that operates separately, distinctly from Article 8 and the route in the immigration rules. And the same applies to settled status. Exactly the same applies to settled status in that regard. I've also had a question going back to absences, asking me to clarify why I say that absences in the 12-month period are calculated on a rolling basis rather than by qualifying years. So why is it 6 months in 2012, 6 months in 2013, and so on? Why is it not that? Why do I say it's a rolling basis? And the answer is that it's born out of the wording of the definition of a continuous qualifying period in Appendix EU. It says that you have your continuous period is broken where there are absences from the UK and islands which exceeded a total of 6 months in any 12-month period. And in my view, that the use of the word any there is intended to suggest that if you chose any 12-month period within a 5-year continuous period, and you can find more than 6 months of absence, then that's enough to undermine your application, rather than it being that you're allowed 6 months in 1 year, one academic or calendar year, and then 6 months in another. Surinder Singh, there's a question about Surinder Singh. A gentleman arrives in September 2019 under the Surinder Singh route as the partner of a British citizen. They have a residence document which is valid for 18 months until the end of 2021. Do they need to apply for settled status now under the scheme? And will they qualify for settled status once they attain the age of 65 in a few months? There are two questions here. The first is, the answer to the first, should he apply for settled status, pre-settled status now? Yes, he absolutely should, because his entitlement under the Surinder Singh route as a matter of EU law will come to an end. And so it's critical for them to apply for pre-settled status now. And the existing residence document, the thing that they currently have, is useful because it hopefully should mean that they don't need to resubmit all of the evidence later to get that document attesting to their Surinder Singh entitlement again. So that all of those parts of the 61-page application form that you need to fill out to avail yourself of the Surinder Singh entitlement won't need to be filled out. The settled status doesn't arise upon the age of 65, so it won't arise in a few months, but it does arise after 5 years of continuous residence in the UK. So that's the answer to that question. And then two more, which I can deal with very shortly, and then the rest I'll leave for written answers. The first was, is an EEA national with settled status required to apply for permanent residence if they wish to apply for British citizenship? The answer is no. They can apply directly for British citizenship. And then finally, do the more favourable EU spousal rules, e.g. no language tests, continue to apply for the non-EU spouse of an EU national joining the EU national after the 31st of December 2020? And are there any caveats? The answer to that is we frankly don't yet know, because that's not a matter for the transitional arrangements and the settlement scheme. That's something that is left to be determined by whatever immigration system EU nationals and their family members find themselves in after the transition period comes to an end. So that's still to be determined. I hope some of those answers are useful to those who ask the questions.
And I'm also happy just to very briefly take one question on the Fratila challenge, which was, does the case not assist non-EU family members with PSS? I'll certainly check it for written responses, but my initial feeling is no, because it was an Article 18 discrimination challenge. So in order to bring a discrimination challenge, you'd have to be someone who holds that right in the first place, like an EU national. So for that reason, I'm fairly sure the answer is no, but I will double check that for written responses.
And on that topic, there's somewhat later in the chat, Martin Williams has given pretty well precisely that answer. The protection is only under Article 18 to EEA nationals, and therefore not to third country family members who might have rights under EEA legislation. That's not within the scope of Article 18, as I have found out to my cost from time to time.
I've just spotted that, yes, brilliant. Okay, good, I'm glad.
But, do check it.
Right. Of course.
Not for a moment suggest you go and check it. But, right, okay, well, there were limitations to how much we could do on the question, on the Zoom chat function. I would just like to bring things to an end at this stage. I think it's a natural point to do so. And once again, to thank all the speakers and all the participants and everyone who's fired off has used the chat function in a very helpful way. And we will have a hard look at what's there and what we can provide by further material on the Chamber's website in response to the chat. But anyway, thank you all very much, and we sign off now. Thanks again. Thank you.